In fact, Will sent us an email, and his question goes a little something like this. The stairwell at my apartment complex doesn't drain properly and it can get a bit slippery after a storm. I was told this when I moved in, but I still managed to fall and break my wrist last week. Can I get them to pay for my ER bills? Or am I out of luck since I already knew that this was an issue? Now, that happens to so many people when they see something and they still have to work around it, and yet an accident happens. So, Harry, what are your thoughts?
A couple of things come to mind. First, the fact that you were injured on property probably means, with an insurance company carries what's called MedPay, medical payments coverage. And so regardless of whether or not you make a negligence claim, there's probably going to be some amount, it's usually not a lot, but there's some amount that can go towards paying your medical bills. Now, in order to make a negligence claim, you obviously would have to show that they did something wrong. They did give you a warning, and that will come into play. But let me give you an example. Let's say you lived on the second floor of an apartment complex, and that was the only ingress egress. Okay. The fact that they told you it might get slippery when it rains, there's only one way into your apartment and one way out of your apartment. And if that's the only way in and out, the fact that they know that it gets slippery means they should also go fix it. So I think there'll be a comparative negligence component, but I think you can still make a claim, but certainly the fact that they warn you will come into play.
I had a case a couple years ago against an apartment complex, and there was an ice storm, and my client lived on the second floor, and she slipped and fell and broke her leg, had a pretty serious injury. And we went to trial, and what we were able to show is that the management company had sent out a memo saying that you need to go ahead this spring and winterize every apartment. And by doing that, you need to have sufficient supplies of rock salt or ice melt to sprinkle onto the stairs and the common areas like the walkways and sidewalks in case we have snow. Because if we get it here every few years, we'll get an ice storm or a snowstorm in Mississippi. They didn't do that. They violated their own policy. They could have done it. They were told to do it. And because they violated their policy, my client was hurt. And guess what? The jury found that company negligent and liable for a 6-figure verdict because of the violation policy. So if they know they're supposed to do something and they don't, and it causes or contributes to an injury, you got a good chance of winning your case.
All right, which is all the more reason why they should give you a call, without a doubt.